Yes. When you want to withdraw, Mr. Arbitrary, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to avail remedy for filing an appeal under Section 42 of the PMLA Act 2002, and therefore would like to withdraw the instant petition without prejudice to file the appeal. He further submits that the period during which the period from the date of filing of the instant petition till date be excluded while completing the period of limitation. Taking into account the above, the instant petition stands closed on withdrawal. Liberty given to the petitioner to file appeal under Section 42 of the Act of 2002. It's so permissible under law. Further to that, the date from, further to that, the period from the date of filing to filing. And so till date, till to date, be excluded while completing the period of limitation for filing them. And so for appeal. Unlisted. Huh? Item 22. Mr. H.R.A. Ahmed, the lead counsel for the petitioner seeks for an accommodation in the matter. This is the matter again on calendar night. 18th of May 2026. Item number? It's the counsel appearing on behalf of the petitioner submits. We have taken the consent from the other side. Mr. L.R. Mojumdar, have you taken the consent from him? You've taken the service. Then it is to be served again. Who is appearing? But if you have not filed your dusty affidavit, so we have to ask you to take service again. Do whatever it is. We'll look into it. We'll take it up in the second half. Twenty-third is Thursday. Why? What about 24th? Yes, the additional secretary to the government of Assam Revenue and Disaster Management Department.
My lord, I'm present, ma'am.
Yes. Now, why in this case the permission has not been granted?
My lord, I sincerely apologize before the Honorable Court for the delay in submission of the status report to the Honorable Court. My lord, there was no lapse on the part of the department so far as the application has been processed on 29/3/2025 and it was kept pending at Deputy Commissioner level for 9 months.
But
Thereafter,
isn't it the mandate of law that you are to dispose of such application within 30 days?
yes, my lord,
That
within
you see,
45 days,
you get the source of power for issuance of the NOC in terms with Section 21A.
my lord.
Unless Section 21A is not amended and thereby enlarging the period beyond 30 days, you are to dispose it of.
Yes, my lord.
But this is not done. Here, in this case, there is nothing out here which has been placed. Mr. Additional Secretary, we don't have the intention of calling you. I know you are a busy person, but the thing remains that when you are not being provided with the instructions, it becomes very, we have to do it.
My lord, I
Here
sincerely
the
apologize
notice
for
was
this.
issued on 18/8/2025. We'll be nearing a year in another 4-5 months.
My lord. Now the application has been disposed and the NOC has been issued, my lord.
When do you give an undertaking that something would be done in that regard?
My lord, the NOC has already been issued yesterday.
Issued.
Yes, yes, my lord. Yes,
Okay.
my lord, issued.
Okay then. Then we are. Then we close the petition as the NOC has already been issued. You have a copy of the NOC?
Yeah, that will be taken by the applicant from DC's office. That has already been issued in a status report that can be checked.
Okay. Okay then. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. So-and-so, who is the additional secretary to the government of Assam in the Revenue and Disaster Management Department, is present through the video conferencing link provided by Ms. N. Bordloy, the standing counsel of the Revenue and Disaster Management Department. The present petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in providing the permission in terms with Section 21A of the Registration Act 1908 insofar as the same is applicable to the state of Assam. It has been brought to the attention of this court that on 7/4/2026, the permission have been duly accorded. A copy of the said permission, which is being placed before this court during the course of the hearing, is kept on record and marked with the letter X. Taking into account the above, this court therefore finds there is no live cause of action which arises in the remains in the instant proceedings. Accordingly, the petition stands closed. The personal appearance of the additional secretary to the government of Assam in the Revenue and Disaster Management is dispensed with. Okay, Mr. Additional Secretary, we ask you to the next occasion you kindly look into it. We don't have the intention of calling your presence, asking your presence, but if it is done as per law, it is much better.
I sincerely apologize, my lord.
Yes. Okay. Thank you.
Thank you.
Vahabi Prasadji, what is this matter about? Release of This is done under what provision? Under some Land Acquisition and Requisition Act. So then you have to seek a reference of you have to refer it. I think Section 30 of the Land Acquisition Act 1895 has been statutorily incorporated into the provisions out here. So you cannot decide this. And why the circle officer has, I think, better things to do? You should have made a reference to the court. Are you doing it? Sir? Obviously, that is the mandate of law. That is the mandate of law. That you do one thing. There appears to be some. You have asked for that as per the Land Acquisition Act. You refer it. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Who appears for a private respondents? Notice has not been issued. Oh. Okay, anyway. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. A. Bhachaji appears on behalf of the Revenue and Disaster Management Department of the Government of Assam. Mr. N. Goswami appears on behalf of the respondent number 3, 4, and 5. The grievance of the petitioner herein, taking into account the order which this court proposes to pass, the notice upon the respondent number 6, 7, and 8, 6, 7, 8, and 9 are dispensed with. The case of the petitioner herein is that the petitioner is the owner of a plot of land which has been specifically described in the schedule to the writ petition. Pursuant to an acquisition proceedings being initiated under the Assam Land Requisition and Acquisition Act 1964, which have been registered as LA case number 4/2025, the land of the petitioner is claimed to have been acquired in the said proceedings. It is the further case of the petitioner that the vendor who had sold the land to the petitioner subsequently, the vendors of the petitioner who sold the land to the petitioner subsequently sold the lands to the respondent number 6 to 9. And therefore, it is the case of the petitioner that no valid title could have been transferred by the vendors of the petitioner, taking it in view of Section 48 of the Transfer of Property Act 1882. Be that as it may, taking into account that the acquisition proceedings have been initiated, the petitioners approached the competent authority claiming the compensation. However, the compensation amount has not been paid, and the petitioner apprehends that the said amount would be paid to the respondent numbers 6 to 9. And it is under such circumstances the petitioners have approached this court. I've heard this court duly takes note of that by an order dated 23/2026, instructions have been sought from the learned counsel who appears, learned government advocate who appears on behalf of the respondent numbers 3, 4, and 5. In pursuance to that, an instruction has been placed before this court dated 4/4/2026, issued by the Additional District Deputy Commissioner of Land Acquisition Branch, Kamluk Metro District, wherein it is mentioned that certain hearings were conducted. However, no compensation amount had been released to any person in respect to DAG number 1237 of Pata number 12 of Village Sahar, Gauhati, Part 1, under Gauhati Moja, which is the scheduled land in the instant proceedings. The said instructions are kept on record and marked with the letter X. This court further takes note of that these acquisitions which have been carried out being an acquisition made under the provisions of the Assam Land Requisition and Acquisition Act 1964. Specifically provides that in the case of there being a dispute as regards the entitlement and or the apportionment of the compensation, such disputes are required to be referred to the court in terms of Section 12 of the Act of 1964. This court further takes note of that in terms of Section 12, bracket 2 of the Act of 1964, the provisions of the Land Acquisition Act 1894 have been statutorily incorporated into the Act of 1964. The resultant effect of such statutory incorporation is that by virtue of Section 30 of the Land Acquisition Act 1894, when a dispute or dispute arises as regards the entitlement and or apportionment of the said amount, the court, the revenue authorities cannot decide the said aspect, and it has to be referred to the court. And further to that, the compensation in such a case, the compensation which is payable in respect to the acquisition of the land has to be deposited to the court, which will be subject to outcome of the proceedings before the court. Considering the above, this court therefore disposes of the instant petition, thereby directing the respondent number three to respondent number 3 to take steps for making a reference to the court of the learned district judge, Kamrup Metro, to decide on the question as regards the entitlement and apportionment of the compensation in respect to the plot of land which have been acquired at measuring 5.65 R, covered by DAG number 1237 of Patta number 12 of village Sohor, Gauhati, Part 1 under Gauhati Moda. The said be done within a period of 30 days from the date of a certified copy is served upon the respondent number 3. This court further observes and directs that taking into account Section 31(2) of the Land Acquisition Act 1894, the amount of compensation be deposited by the respondent number 3 before the court to which a reference has been made as per the directions so passed herein above. The amount of compensation so payable shall be subject to the outcome of the reference proceedings before the court. You won. Huh? Better. In fact, yesterday I was looking into the judgment of the Supreme Court on the state of Arunachal CBI inquiry. The propositions which are laid down squarely is expected. So you are therefore saying that we are going to retender? Sure. Issue notice making it returnable on 20 29th of April 2026. Mr. S.S. Roy appears on behalf of the respondent number 3 and accepts notice. Extra copy of the writ petition be served upon him during the course of the day. As regards the respondent number 1 and 2, the petitioner is directed to take steps by speed post by tomorrow. The petitioner further is given the liberty to take steps upon the respondent number 2 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner is aggrieved by the actions on the part of the respondent number 2 in freezing the petitioner's bank account bearing number maintained in the respondent number 1 bank, Dhubri branch. The bank account, the savings bank account number of the petitioner is 20230 64620 It is the case of the petitioner that the said bank account have been frozen on the basis of certain communications received from Mr. Counsel. First of all, why haven't you made those persons who have issued the communication a party? Why? Why you have not made that person a party, the station house officer a party? Then what do you want? The case of the petitioner, bank account number so and so. It is the case of the petitioner that the station house officer Uttar Pradesh, Bhalia Bansi, had sent an information to the respondent number 2, informing that certain amount, an amount of rupees 29,224 was a proceed of cybercrime. And thereupon the said amount of 29,224 have already, and thereupon, and immediately thereupon, the petitioner's bank account was frozen. It is the further case of the petitioner that the said amount of 29,224 have already been deducted from the petitioner's account. But till date, the petitioner have not been permitted to operationalize the said bank account. It is under such circumstances the petitioner had therefore approached this court by filing the present petition. The respondents herein, and more particularly the respondent number 1 and 2, are directed to apprise this court by way of an instruction as to why the petitioner's bank account should not be allowed to be made operational on the next day. Yes. This is section 12A. Now, this is the certificate given order under 12AA. So your registration is still intact. So now, if Mr. Seke, if we come to section 12, capital A, double A, 3, Roman 3. Now you are registered. Now, once you are registered, we come to say that it needs to be cancelled. It has to be cancelled by way of a particular procedure. So it has not been cancelled. So now, once it is not cancelled, what are the benefits you get? Yeah. Provided, provided that the advancement of an But are you a subsidiary of the BCC? So therefore, wouldn't that be your income? Understood. So your entity is different from BCCI. So therefore, any amount paid by the BCCI to you would be your income. So therefore, so they give only what? So what would be the subsidy? What is the form of receipt it would be? Capital or revenue receipt? No, you see, we have to look into the income tax from the taxation point of view. Now, what type of receipt would be? Would it be a capital receipt or a revenue receipt? If it is a revenue receipt, then the payment will be different. It has to be treated differently. But if it is a capital receipt, it will be treated differently. So these are various forms of receipts. Ah, that is what. If it is a revenue receipt, then it is payable. Tax is payable. That's the problem. Where is the order? Where is the order? No. Where is the order? Impugn order? And why we are looking into this in the 226 when you have an appeal? Wait, they're referring it at page 140. This is AICT exemptions versus Ahmedabad Urban Development Authority. The State Cricket Association must be assessed annually to determine if the commercial activity violates the provision of so and so. I want to emphasize that if receipt from commercial endeavors exceeds 20% of the total receipts, the exemption claimed in relation to charitable falling under enhanced general public utility is to be denied as mandated under so and so. Page. Yes. No, no. So the moment it is minutely examined, it is for the appellate authority. Why should we look in? It is for the appellate authority. No, no. That is therefore the power is there to treat it as a revenue receipt or how to arrive at. These are things which are to be looked into by the appellate. No, not to them. You file an appeal. This is an assessment order. The issue is settled by the Supreme Court in the regard that yes, it can be looked into, but you have to do minutely look into all these various intricate details. Now, if you say that these intricate details were not looked into, it is a case which has to be decided by the appellate forum. Why should we look into it? But Mr. Secretary, why should we interfere in this, look into this when this can be very well looked into in the appellate forum? Commissioner of Appeals will look into it. Income tax, they are much better off. The DCK, the limits senior counsel, hearing assisted by Mr. B. Ogoi, appearing on behalf of the petitioner. Association seeks for an accommodation. List this matter again on Saturday. In the 5th is Saturday. In the 6th is Sunday, 27th and 27th. Yes, Mr. Nayak, what is your instruction? Which state? Which state? We will stay. That's okay, not necessary. If these are the instructions, then we can decide this. No, let the Supreme Court decide or division bench decide. This type of thing. This is not the thing which we can allow. For the face of it. We state for the time when issue notice. Issue notice making it returnable on. When can you file your affidavit? On when do you want it? Let's have it on 27. Issue notice making it returnable on 27/4/2026. Mr. Pinag accepts notice on behalf of the respondent number 1 and 2. Extra copies of the petition be furnished to him during the course of the day. The petitioner herein has approached this court, challenging the actions on the part of the respondent authorities in issuing an advertisement on 3rd of March 2026 pertaining to a notice inviting tender for construction of roads and bridges project under SOPD-G for the year 2025-26 in Borpeta district of Assam, amounting to rupees 1112.98 lakhs, including GST, etc. On one hand, and further mentioning in the said advertisement that the details can be seen from 6/3/2026 at the website www.assamtenders.gov.in, and on the other hand, making the said tender available in the e-tender website, in the Assam Tenders website only on 13/3/2026, and mandating that the same should be deposited and further mandating that the end date to be on 16/3/2026, thereby leaving only Friday, Saturday, and Sunday. Mr. R.M. Decker, appearing on behalf of the petitioner, submits that not only a perusal of the press notice inviting tender, as well as the website dated website of www.assamtenders.gov.in in respect to the contract in question clearly shows gross illegalities on the part of the respondent authorities to handpick their blue-eyed persons, but also clearly violates the provisions of the Assam Rule 12 of the Assam Procurement Rules 2020. When the matter was listed before this court on 7/4/2026, Mr. P. Nag, the learned standing counsel of the PWD, had submitted that he would obtain instructions today. Accordingly, this court sought fix the matter today, thereby enabling the PWD authorities, the respondent authorities, to place instruction as to the authenticity of Annexure C, page 22 of the petition. To the said instruction, Mr. Pina today have placed an instruction issued by the Chief Engineer PWRD dated 7/4/2026, which is kept on record and marked with the letter X. For perusal of the said instruction, it is duly mentioned that the notice inviting tender was widely published in the newspapers, namely the Pioneer National Daily and the Assam Tribune, on 3/3/2026. There is no denial to the fact that the publication in the Assam tenders.com was of the tender in question was made only on 13/3/2026, thereby admitting to the communication, admitting to Annexure C to the petition. The fact it has been, however, mentioned in the said instructions that despite the short duration, 5 bidders have participated in the bidding process, and thereby mentioning that there was adequate competition and no prejudice. In the opinion of this court, in the prima facie opinion of this court, the said action on the part of the respondent authorities to make the tender online available only on 13/3/2026. That too, after making due publication in the newspapers that it would be available on 6/3/2026, clearly shows that, apparently shows that the action on the part of the respondent authorities did not, shows that the respondent authorities, for reasons best known, did not want proper and adequate competition, merely because of the fact that there are 5 bidders who have participated, would not there cannot be a ground to hold that there was adequate publicity, taking into account the said. This court directs the respondents to bring on record their stand by filing the affidavits. It is further observed that till the next date, no steps should be taken for finalization of the tender relating to the construction of roads and bridges project under SOPD. Yeah. Rule 10.
Silently. Audio also.
Yes, have you made the rules? Mr. Chaudhary, I was thinking the reason why you filed the petition, I've already taken care of it by passing the order. Let me place the matter before the administrative side, before the Chief Justice. And whether he would like to continue on the judicial side by taking it by himself or by through any other division bench, I think it would be better. In fact, if I'm not wrong, this matter was taken initially by 5 judges. It was taken by 5 judges. In fact, this is a matter which requires 5 judges. It is really disheartening that the Gauhati High Court does not have a rule for 77 years. It's something like the Gauhati High Court had abdicated its powers to the mercy of the state. And you do whatever you pay us something, we'll be happy with you. Supreme Court has their own rules. All high courts have their own rules. All high courts have their own rules. You may get it is something like this. If I may give you a metaphor, let's take the example of a freedom struggle of the country. We may be doing fantastic under the British. At the time when British left, we were poor, but at least we had our independence. It seems that we are in the same status where the High Court is still under the mercy of the states. They have a payroll and they give a PSP. Okay, principal seat, we give you some PSP, and this is the language used. 77 years. The British was here so much, and still the British remains for the High Court. I think this is a matter which I think the Chief Justice should take it up as at least by 5 judges, not by judges of only 2 judges even. 2 judges also I don't think. Because at that point of time, if you remember those matters were taken up, they were by 5 judges. Yes, there were 5 judges who took it up. But they went on a different tangent at one point of time, and this led to the astray. They say that let us await the outcome of outcome of the pay commission of the Assam government. And therefore, matter got adjourned. And thereupon it was broken up because initially at that point of time, when the 5 judges were there, all advocate generals appeared. And they have categorically come up and said that look here, there has to be a separate. That was at that point of time when these 5 judges were sitting. That they did it. Kindly see this. This was the, I think, with due respect to the 5 judges, they made this colossal mistake. Isn't this contrary to 229? Nothing to do. And in fact, in the Assam Pay Commission, it is mentioned that it shall not apply to the Gauhati High Court because it cannot. A different aspect. We are given the independence by the Constitution. But I think the provision has to. Yes. Not only the judges' salaries are taken from the court. Yes. No, no, in fact, if you see 229, and forget about the High Court judges, independence. Independence is there, so therefore you put it in the consolidated and you cannot touch it. Not only the High Court judges, even salary of the registry under 229(3) is to be from the consolidated. The reason is because of the registry, the independence of the judiciary should not be. This is what the Constitution is famous. Yes. And do you know the reason why this has happened? That day I was picking up. In fact, you are the president of the bar. You should take it. Law clerks advertisement is being made by the Gauhati High Court for the judges law clerk. You know what is one of the qualification required? That he has to have, he should be, one qualification is that he should be practicing in the bar or having legal knowledge to the field. And another condition is he has to be enrolled in the employment exchange. Isn't it the most demeaning of a noble profession? Isn't it the most demeaning thing? I put an effort, asked the Gauhati High Court to file an affidavit saying, how is it possible when a person has a license? No, now, if a person has a license to practice, can he say that he's unemployed? Now, the reason, do you know why? Because the Gauhati High Court can consider itself, because this is the mandate of the state government, that when you are employing somebody, you have to get the year from the employment exchange. Yes, that is why we don't have in now. I don't think the High Court should be a department of the. In fact, they were. Yeah. Yeah. Because I tell you one thing, that we were taking on out from the infrastructure bit. The infrastructure, then they have a particular amount for housekeeping. Now, this housekeeping means you, without taking the conference in finance department, you can very well spend. Amount is 25,000. Okay, so just for example, in somebody's office, 25,000 without concurrence, you can do it. They were putting this particular notification applicable for Gauhati High Court and saying the 25 beyond anything, you take the finance. This was the state of affairs. We had to pass orders. After passing order, now they have made it 1.5 only for the High Court. 1.5 crore. This is how. So therefore, I think best, yeah, let this matter with this. Heard Mr. K. Chaudhary, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Government Mr. T.J. Mohanto, the learned standing counsel, senior counsel, who is also the standing counsel of the Gauhati High Court. Who is paying for the stay of the firm? Anybody? You kindly give your name, sir. Assam, Nagaland, Meghalaya, from Nagaland, Arunachal Pradesh, and The instant petition was filed by the petitioner, being aggrieved by the action on the part of the finance department of the government of Assam in rejecting the approval to be granted under Article 229(2) of the Constitution of India by the speaking order dated 3/8/2022. This court, by the detailed order dated 19/6/2025, set aside the said order dated 3/8/2022 and further issued certain directions which have been specifically mentioned at paragraph number 37 of the order dated 19/6/2025. Paragraph 37 of the same order, being relevant, is reproduced hereinunder. It has been brought to the attention of this court that in pursuance to the said judgment passed by this court, the order passed by this court, that the Chief Justice on the administrative side have constituted a committee for the purpose of framing the rules as is required under Article 229 of the Constitution of India. When the matter was taken up on 18/12/2025, again on 2/4/2026, as well as today, it has been brought to the attention of this court that the said committee so constituted by the Chief Justice is deliberating on as to how the rules draft, how the pay rules, how the rules to be framed under Article 229 of the Constitution are to be made. It is also being mentioned, informed to this court, that steps are being taken for the purpose of drafting of the same rules. Taking into account that the relief which have been sought for in the requisition have already been granted by this court in the order dating 19/6/2025, as aforenoted at paragraph number 37 of the said order which have been quoted herein above. It is the opinion of this court that insofar as regards the adjudication of the instant proceedings, nothing remains for this court to look into it. Be that as it may, it is also equally important to note that 78 years have passed by from the date of establishment of the Gauhati High Court until date. The conditions of service of employees of the Gauhati High Court in respect to pay, leave, pension, allowances are yet to see the light of the day, in spite of the clear mandate under Article 229 of the Constitution. It has been also, attention has also been drawn to this court that most of the high courts in the country, as well as the Supreme Court, have their own rules insofar as pay, leave, pension, allowances, etc. Because taking into account this court, therefore, places the matter on the administrative side for the Chief Justice, before the Honorable Chief Justice of the Gauhati High Court, so that a decision may be taken as to whether there is a requirement of monitoring on the judicial side the the draft rules, taking more particularly taking into account the judgment of the Supreme Court in the case of High Court Employee Welfare Association, Calcutta. And others versus State of West Bengal and others reported in 2007, 3 SCC 637. That's the subsequent one of Mr. Chaudhary. Yes, yes. I think this is the one where the Supreme Court say that all after everything is being
I think
done
2004 1 SCC 334.
of the judgments of the Supreme Court in the case of High Court Employees
Welfare
High Court
Association,
Employed Welfare Association, Calcutta
Calcutta
and
versus
others
State of Bengal.
versus State of West Bengal and others reported in 2004 1 SCC 334, as well as the High Court Employees Welfare Association, Calcutta and others versus State of West Bengal and others reported in 2007 PSCC 637. Which the registry shall do the next. If
But the IA is for vacation, vacation of the order. Logic will kindly pick up the IA. The order logic will find up page number 14. Page 14 of the IA. We have prayed for modification of the order. Well, by this order at page number 16, logic has while issuing notice directed.
wait. Let us hear it. What is your case?
I am appearing for the respondent in the IA law.
Forget about respondent. What is your case as a petition?
The petition person.
Yes, it was.
Firstly, we have challenged the order passed by the respondent number 4. Logic may kindly see the notice.
Which order?
At page 21.
Notice for removing shock unit. It is to inform you that as per public complaint in the report. Okay, now tell me, what is wrong?
Here are two villages, adjacent villages, namely Manaspara and another is Manaspara Reserve. And these two villages are divided by one PWD road, that is Lokhipur Jaleshwar route. And Manaspara Reserve is on the north side and Manaspara is on the south side. And the Lokhipur Municipal Board or Municipal Bazaar is in Manaspara Reserve, that is south side of the Lokhipur Jaleshwar road. Now, I am possessing a plot of land in Manaspara Reserve, and that is Panchayat area, Lordship. Takimari Hagoripara Gau Panchayat. That is Takimari Hagoripara Gau Panchayat. That is Panchayat area, Manaspara Reserve. And I have purchased that plot of land in the year 2011 from one person, and that person was possessing the land since 60 years. Since 60 years he was possessing. Thereafter, I purchased that land in the year 2011, and on the strength of purchase, my name was also recorded in revenue record. Lordship may kindly see the Sita copy I have annexed. Sita copy at page 19, Lordship. My name is there.
Village Manaspara.
Yes, Lordship. Manaspara Reserve.
What is your name?
My name is Nurul Islam.
Son of Aya measuring Kolkata 5 lecture. PVRG reserve. What is this PVRG reserve?
Village Grazing Reserve, Lordship.
You are having what?
No, Lordship. Now, that is not question. Question is that the municipal, no, Lokhipur Municipal Board is,
Has the power or not?
yes, Lordship.
Now, what happened there?
They have issued that impugn notice, Lordship. And my learned senior has submitted the IA, wherein my learned senior has annexed one document. Lordship may kindly see page 10.
Yes.
Page 10. The relevant portion is at page 12, Lordship. Serial number 7. Page 12, serial number 7. This 2 bigha 4 kata 15 lesser land was allotted to the municipal board on 9 September 2022 by the SDLAC, Subdivisional Land Advisory Committee. Lordship.
In favor of the Lokhipur Municipal Board.
Yes, Lordship.
And
And that land is outside the area of municipal board. And that land is
Right,
in,
we will look into it. What is the date of this document?
Lordship, can I skip off 9 September 2022.
Huh?
9 my notes of subdivisional land
9 September.
9 September 2022.
Yes. But what it? No, indeed, the land is government. It's a government concept. Logic, no. First of all, what power you are exercising? But you cannot exercise the power of under the Assam Municipal Corporation Act under. We can no how? Okay. The provision of the Assam Municipal Act 1956, 159. 159 says that the removal of obstruction or enforcement in or on public road. It says the board may issue a notice requiring any person to remove any building which he may have built or any fence, rail, post or other obstruction. Yes.
Or
No,
enforcement.
no. Mr. The board can. The board can. But here is an allotment being made. Just let us take the example. Can you tomorrow in Delhi, Assam government is given a land for purpose of construction of house. Okay. He goes and resides there. Can we exercise ability? Opportunities. Think. But it does it fall within the boundary of your document? Yes. Then why then an allotment had to be made? If this is the document at page 11, is the document by which allotment has been made by the DC, means it is not a part of the municipal board.
It was a government khas land.
Maybe
That khas land has been given for the
Therefore, I'm
purpose of the
giving you-
market.
it's like therefore I'm saying that the state of Assam, with an example is Delhi. But my question is, how is particular land which is being allotted tomorrow? The locating municipal board is allotted some land in Gauhati for having some office. No, I'm asking you, can you exercise that power?
Here, kindly see, if a market is running, Matlab, for the purpose of extension of the market.
No, file civil suit, but not this model.
No,
You have been
under-
allotted
under-
the land, you have been approved the land. Where is the allotment?
matlab, land has been, SDLSE has given the land in the year 2022.
Where is the allotment?
Land
This is only the minutes.
minutes, matlab, in para 20, in para
No,
3,
don't you require that where the leaves?
but land has been allotted and the land.
No, can the SBNC allot the land?
Yes, no.
No, they make a recommendation.
So ultimately,
Let us see the
Para-
Assam land policy.
para 4 we have said.
No, no, Assam land policy, where is it? Can the SBNC allot the land? It's,
You will see what the right petitioner has.
no, he doesn't. But
So-
you have, no, he does not. But you cannot invoke the
Kindly-
municipal act against him.
Now kindly permit me to read 159.
Yes.
Section 159. The 159 specifically says that, I'm just, let me read. The board may issue a notice requiring any person to remove any building which he may have built, or any fence, rail, post, or other obstruction or encroachment which he may have erected on any public road, house, gully, public drain, water course, ghat, or any land vested in the board. So if he
So
is
therefore,
erecting,
can you exercise 159? And therefore I say, can you exercise 159 of a land which is allocated in Assam in Gauhati? My simple question is this. Can you? That is the answer to the entire problem.
Matlab, that land is within the jurisdiction of the Lakshmipur Municipal Board. This is
Who is
not,
that?
this is not
No, no,
outside.
if you, then if it is, no, no, if it is within the jurisdiction of the municipal board, there is no problem.
It is
But
within,
why is it requirement that it has to be allotted by the SDLS?
because it is a khas land. It is, matlab, kindly see that particular chita copy, document, matlab, is live. Kindly come to that. In the left corner, lot you will see, it is Sorkari. Page number 20, kindly see page 20.
Okay?
Page 20,
Of your affidavit.
no, in the read petition, he's lying on the chita copy. Page, and exactly page 20, it is government.
20, yes.
What, in the first column, Pottadarar Nam, Pitar Nam or ঠিকানা, Sorkari. It is government.
No quarrel.
So that government land has
No,
been
no,
given to
that-
us.
my question is tomorrow in the TB hospital land where you have evicted a lot of people, the people municipal board is giving up lot of land. Can you exercise 159? My question is that. You can very well. If you don't, nothing.
Matlab, if Lakshmipur Municipal Board of Walpara is given land in Gauhati, I'll examine that.
That is the
Otherwise,
question.
no.
No,
Here the question is,
no,
why
no,
has to
therefore it's
kindly-
not the
kindly
government
listen.
land. See, the municipal board. The municipal board is given a jurisdiction having court under the boundary.
Yes,
Is this land within the court boundaries of the boundary of the municipal? Board?
absolutely.
Where is the document?
But in fact, in para 4, we have said that after that, we have made the application and land has been handed over to us. And we found,
Where is it mentioned? Because his specific question is, Manaspara Reserve is outside the jurisdiction of Lakshmipur Municipal Board.
in fact, the SDLSE, while deciding, they have also indicated in the third column, which the SDLSE minutes, page number 11, it starts, kindly come to page number 12. The specific purpose is in favor of Lakshmipur Municipal Board for establishment of Polimari Bazaar. But this Polimari Bazaar is already going on. And matlab, in fact, for extension of the market only, that some more land has been given to them. So so the municipal board cannot matlab, establish a market beyond their.
Let us see the boundary of the state of a municipal property. Let's see. What is the boundary of a municipal board? Like GNC, we have a boundary.
Yes,
TMDA, we have a boundary. So what is the boundary of a municipal board? Who makes?
the municipal board cannot establish a market beyond their-
Effect including
beyond their
area in
jurisdiction.
local area. Finally, see, notification of intention to create, alter, limits or abolish municipality. The state government may by notification in the official gazette and by any other means as it may determine declare the intention to constitute any town together with or exclusive of any railway so and so under there to include within them any local area contiguous to the same to so and so. Where is this notification?
That notification, I will take, I'll take it.
You bring it. If this land falls within it, no problem.
I'll
You take
take
it.
it. I'll take it. Otherwise, no.
Otherwise, Mr. Problem. The problem is you cannot exercise 159.
I kindly appreciate how the municipal board will establish a market if it is not within their jurisdiction. This is for a market. This is for construction of a market. Polymer budget.
Mr. Nath, we find out here cases where town panchayat gives permission to somebody for running farm market. The Ansalik panchayat, in order to disturb them, takes on rent another place and it's and holds a market. This is also a thing.
Notification.
Therefore, you just produce.
The jurisdiction of notification.
There it is only a simple question of jurisdiction. You produce that within the limits, this land is there. That is all.
I'll take that.
If that is not there, then that is the
Can this is 24. This 24 map is there. I have annex.
where
Yes. This 24 and 26. 8 is 24 missing lots.
24, yes.
This is pertaining to Manaspara.
Where is the market?
And this 26 pertaining to Manaspara Rugar. And I have marked some.
Huh? Where is your land?
Approximately can you see? I have highlighted disputed land is there.
Mr. Counsel, tell me one thing. Page 24 and this 24, there is a difference.
I have made Xerox from the 24 only.
It can't be.
From this.
No, it can't be because the yellow portion is not there at page 24.
Sorry, Lordship, that is what I have submitted, that I have, for better understanding, I have highlighted that portion.
But who put this 24, this portion, yellow?
Yes.
Not yellow, the extended portion. You see this particular
Yes,
small portion,
yes, that portion I have.
but this is
that
not here.
I am possessing that portion, Lord. I am possessing that portion, Lord. And just to place that, I have highlighted that portion, Lord. I am possessing that, Lord. And there are 600 bighas of more than 600 bighas of land in Manaspara Reserve. They are not taking the other land. Only my land is they have issued notice for that land only, for my land. There are vacant land also. Adjacent to the Lokhipur Jaleshwar Road, there are.
So you say Manaspara Reserve does not fall under the municipal area. It is only in, it is Manaspara
Yes,
is the area,
yes, Manaspara.
but reserve does not fall.
Reserve-
And your land as per the Sita
Yes.
is Manaspara Reserve.
Yes, so that is also mentioned there.
Heard Mr. So, the legal counsel appearing on behalf of the petitioner, as well as Mr. Deenat, who appears on behalf of the Lokhipur Municipal Board. The petitioner herein have assailed the communication dated 16/5/2024 issued by the Executive Officer, Lokhipur Municipal Board, on the ground that the Lokhipur Municipal Board has no jurisdiction over the said land in terms with the Assam Municipal Corporation Municipal Act 1956. Inasmuch as the land wherein the petitioner have raised the construction and is running the business at Puliamari Market is a land falling within the Manaspara Reserve. Manaspara Reserve.
Market and municipality is Manaspara.
Your market which you have done is in Manaspara Reserve.
Reserve.
Ah, that is good. It's in Manaspara Reserve, which is outside the Manaspara municipal area. And in that regard, the Learned Council have referred to Annexure 6 and Annexure 6A to the petition. The Learned Council also referred to the Chitta copy of the surveyed village, wherein it is mentioned that the land in question, wherein the petitioner is shown as an occupier, is a part of Manaspara Reserve. Per contra, Mr. Dinath, the Learned Council, appearing on behalf of the Lokhipur Municipal Board, submitted that the area wherein the petitioner have made the illegal constructions falls within the Lokhipur Municipal Board, and in that regard further submits that the land wherein the petitioner has raised this construction was initially a government land which was specifically allotted to the petitioner, respondent Lokhipur Municipal Board, for the purpose of establishment of the Pholiahamari Bazaar. Upon hearing the Learned Councils, the question therefore arises as to whether the land in question is within the Lokhipur Municipal Board. This aspect can be apparent from a perusal of the notification which is issued under Section 4 of the Assam Municipal Act 1956 in respect to the constitution and establishment of the Lokhipur Municipal Board. The said aspect be placed before this court by filing an additional affidavit by the respondent Lokhipur Municipal Board. List the matter when?
The last of
On 27 or 28, 29th of April 2026. Interim order pastalia shall continue till the next day. No problem. But what is this small thing? Have a look what he's saying. This appears to be different from 24. What is this? Another one? Oh, it has. Because the connected review is.
But if your lordship remembers, it's a case where your lordship has given direction that the tender should be brought to its logical conclusion in terms of the terms and conditions of the NIT, which till date they have not done.
Now, what do you want? Why the IH file?
No, the
No, wait, let us look into it. Now you see, what are thoughts of review? It's not a review. It's more like a clarification. That is why I gave you a see the order which has been passed by this.
Direction is that cannot be.
Now, finally come to page 56
Of the review.
of the
Yes, ma'am.
number D. The respondent authorities are directed to bring the tender process initiated by notice inviting tender to its logical conclusion as per the notice inviting tender dated so and so. Now, this court had gone into the question out there on the earlier occasion on the ground that they have resorted to cancellation of the tender process and go ahead with a fresh tender. The reason which were given in the tender is
They've changed one criteria at the behest of a third party.
be that as it may, in the technical evaluation, the petitioner along with three other bidders were held to be technically responsible. Then everything was done and it was found that the product of Rockwell ensured that the rice line refrigerator meets the standards so and so. On, finally come to page 29, paragraph 15. On 22/7/2024, all technically responsible were asked to submit the meeting which was scheduled on so and so at 11 a.m. in the office of the Principal Secretary to the Government of Assam so and so. On the very date, the following decision was taken and recorded. The procedure of the bidding of ice line refrigerator was initiated within the department. Appropriate internal action to be initiated to avoid such occurrence. No serious bidder vitiating, non-serious bidder vitiating the tender to be debarred from participating after careful hearing. In view of the decision taken on so and so, it was decided that the entire bid process would be cancelled. While issuing notice, maintain status quo as so and so. Then thereafter, this court looked into it, and after all the submissions, this court looked into it.
Probably page 56, point number A.
Court have very either it's 40.
We come to page 50. In the opinion of the court upon the concurrent meeting of the general terms and conditions of the same, whom so and so has quoted, the change from sought to be made to the criteria for certification from so and so to certification only could not have been made by way of insertion in the remark below. The modification of the said criteria as was in the original bid document could have only been made by issuance of a formal corrigenda, which was required to be published in the same manner in which the original document was published. In view of the above, this court determines the first point of the holding that there was no modification to the criteria of certification on the basis of insertion in so and so. This is the first point. Then the second point was they has coming to finding that the witnesses were the very difficult. Raise complaints and regard the technical competence of the commissioner. The records further show the respondent now proposed to de novo conduct a fresh tender process by cancelling the earlier tender on the same terms and conditions. The reason so assigned under no circumstances be said to you. So here the reason why this court interfered it, you cannot cancel the entire process and have a fresh de novo thing on the same terms and conditions. Now, what has happened in the meantime? This court also gave them the liberty directed to bring the tender process initiated by the notice inviting tender dated to its logical conclusion as per the terms and conditions of notice inviting tender dated so and so. Now they carry out again another technical evaluation. While carrying out the technical evaluation, they find that there are requirements which they have to take. So therefore they want to cancel.
Madam, may I put the things into perspective? What had happened, madam, just appreciate certain facts. They are penalizing me only because I have approached this court and nothing. And I'll demonstrate it with their Madam, here is a case where the NIT was issued way back in 13 to 2024, 2 years, more than 2 years back. I was declared technically qualified. My financial, out of 10, 4 were qualified. I was one of them, one of the 4. My financial bid is open. Now it's for the entire world to know what rate I have quoted. Then after I was the lowest tender, they don't issue work order to me. Then on inquiry, we have come to know that by means of a remark, they have changed the tender condition. We approached this court. This court observed that no, you cannot do it. So the original tender condition will prevail and we are qualified under the original tender condition. And hence it has to be brought to its logical conclusion as per the terms of NIT. Now, my lord, I searched the NIT in way that which clause of the NIT empowers them to revisit the technical condition after opening the financial bid. Because first the financial technical bid will be open, then the financial bid. That's how the sequence goes. Now they open this financial bid. Now, my lord, during the entire read proceeding, the earlier round of litigation, they have filed an affidavit. Nowhere did they take this plea. I'm coming to these 2 criteria because I possess those 2 criteria. They don't take this plea. I file contempt. My lord, kindly, I have made some spiral binding just to show how they are taking this court for a ride. Every day they are coming up with new pleas. And my lord, and they are giving papers without affidavit. Papers. I had to take a copy of this paper from the respective counsel and I made a compilation. One of the contender, he writes, under what authority of law I do not know, he writes that they need to review by the department, review the order passed by this court. The language is review the order of the court. He writes it's an interdepartmental letter. It is not a letter to the standing council to file a review petition. They file a writ appeal against this with a interlocutory application for condonation of delay. The writ appeal was withdrawn. Now, after 2 years down the line, they file this review petition and they say that I don't possess this one I think two certificates they are saying, which I can gather from the review petition. They further go to say that none of the bidders possess this because it was not there. My lord, I possess these two certificates. I'll give a copy of these two certificates to my learned the counsel appearing for the contemnants. He can verify it from his department whether this certificate will support. Now, my lord, if because I was because my lord, these are online bidding. The window appears for 15-20 minutes or for 1 or 2 days, and then the window closes. Now, if they would have rejected me on this ground at the initial stage when they have uh, approved my technical bid, well, there is a column which says clarification, and on the right hand there are two columns. One is clarification and other is challenge stroke representation, meaning thereby that if because here against my view it is called as qualified. So there is for me there is no need to clarification or challenge nothing. If they would have pointed out these two deficiencies at the threshold, I would have made my clarification. I would have given clarification or I would have made some challenge because the procedure was they disarm me from my right. They make my right known to the entire world. My lord, I wish to file a detailed affidavit against the review petition. It is only today I am appearing, my lord. I have also made a compilation. I'll make all this a part of the affidavit.
Now, what are the documents why you want to?
Yes.
Yes.
Lordship, may kindly come to page number 77. This is a part of the video from
As regard the documents, I have one line, just one line. As regard the documents, these documents are, my lord, the contract is for supply of refrigerator. These
His application.
oh, my lord, because the content and the both were taken.
It document provides for additional terms and conditions. Page number 77 on annexure 1. Kindly come to the first paragraph. Here, my lord, vibration test product should diagram. Page number 77 in the 2. The first paragraph after the specifications, vibration test. Product should stand 30 minutes on a programmable vibrating table without physical damage of calibration. Calibration certificate from NABL as STQC WHO approved lab should be submitted along with the bid and subsequently to be verified at the time of inspection. This is one certificate. This certificate is not available in the bid. It is not, and secondly, kindly come to page number 78. This is annexure 2. Automatic voltage stabilizer. The relevant is page number 79. 6.1. 6.1, page number 79. Certification of calibration and inspection from the factory at the time of pre-dispatch inspection and NABL certificate of specified model. So these are the two certificates. The 5.1 manufacturer should submit the test certificate from the test lab accredited by so and so and submit the test certificate of so and so. So these are the two certificates.
Which are the two certificates? 6.1 and page 77.
Page 77 and page 17.
Now, this is the same certificate. No? 6.1 and page 77 is same.
No, 77 is alcohol stem thermometer. This is alcohol. This is for the alcohol stem thermometer.
Page 77 is
alcohol stem thermometer.
right.
At the top, annexure 1.
Oh, alcohol stem thermometer. And what is this?
And this is for automatic voltage stabilizers.
For two.
This is for
These are the two certificates.
these are the two certificates. Those are not available in the bid document. And it is not the submission of my learned friend. These are handed over to me right now that he is having those documents.
Now let us see where.
Look,
You have made some criteria.
Yes. These are part of the tender document. In the tender document, it starts at page 58.
What is the name of the petitioner?
It's Mahalakshmi. The committee found while examining the papers, That
So E and F is not here, page 80,
page 82. Page 82 is relevant. Serial number
F and G.
most of the bidders will do not submit. In fact, Mahalakshmi Enterprise at 82, serial number 7. On the additional qualification criteria, the bidder has not submitted calibration certificate of alcohol stamp thermometer from NABL SPQC who approved laboratories. B, on the additional qualification criteria, test certificate of automatic voltage stabilizer from accredited NABL laboratory has not submitted. So these are the two certificates he also did not submit. And it is not his case that these are with his bid document. He is giving me right now. He may purchase another, it was not available with the bid. In fact, MS Raja Enterprise serial number 9, they also did not give. MS Ledgerland, they also did not give. But most of the bidders, they did not submit. In fact, they have, the committee has seen the document of all the bidders. In fact, in respect of Mahalakshmi, they found that these are the two certificates they not available.
Now you have issued some speaking order on 12/12/2025.
It was withdrawn.
And subsequently you withdrew it on the threat of contempt.
It was withdrawn. It was. Ultimately, I entered the matter at a subsequent stage. It happened after. And we see that lordship's direction is without, like, it was not pointed out before the lordship at that point of time. It was not. As per the terms of contract, these two documents, these two certificates are necessary. And in fact, the nature of the machineries which they are procured, like the stabilizer, ultimately these are refrigerators minus 30 degree, minus 40 degree, the will be the temperature that has to be maintained to preserve that particular scene. So this thermometer and the stabilizer are necessary. And for that, these particular certifications are.
Okay, you want to file reply.
Yes, my lord. And
But you can't type it, I mean, allowing it on the name.
now, my lord,
I will, no, not on the basis of that. You see, when I passed the order asking them to bring it to a logical conclusion as per the concept, they looked into it and then found that yes, these are the other two documents that are required. So therefore, they,
My lord.
within that amount.
my lord, these two documents were never insisted upon. My lord,
It's
they
not
have,
insisted upon it.
I will show,
okay.
my lord, that is why, because
But
he has
you
just
don't
made,
have a right.
no, my lord, I will show, my lord, what are the documents which are,
Anyway, no, we should not do anything, but I'm making it very clear that on the next case, I'm allowing him to do this. I'm clarifying it. I'm not allowing it, I'm clarifying it. Therefore, I say it cannot be a rule. I'm asking for a clarification. It's only a clarification as to whether they can, what is the leave being granted as per 57D. That's all.
that's, my lord, my lord, since
Whether
now,
it would be permissible to look for them to revisit the technical commission. That's all.
that's all. Now, my lord,
Otherwise,
my lord,
because
sir,
Mr. Biswas kindly appreciate one thing. There is no question of, there's no time going to do this. They find, yes, there are two grounds which are there in that. Merely because you are, when you submit your price bid, you are always at the risk. And 2024, if you have submitted your price bid and this price bid in 2026, you won't be putting that same one.
my lord will kindly see, my lord,
Anyway, you want to file a reply,
lord,
file a reply.
one liner, I'll find
No,
just one liner.
no, one
Now,
liner.
my lord,
One
Had-
liner,
had-
one liner is only just after the elections of 9. Give one liner to everybody, not more. No more one liner.
Because my lord, this is just to save their skin from the contempt, my lord. Because
There's no contempt.
yes, there was contempt. Because they had,
Understood. You see, they have now taken a decision to be conclude the contempt. Exclude the contempt.
Deliberate, nothing is deliberate.
my lord,
Nothing.
and both has to be because, my lord, I need to put the certain submission, my lord, because in the contempt petition, your lordship will see, therefore I have made this compilation. The stand they have taken every time, and my lord, suppose if this, then both the matters may be taken together.
These things would not appeal to the court. I know if these things would appeal to the court that what has happened, how they do it. I think many more egregious things the government does. This is what they seem to be doing a bit on a much on a better side.
My lord, then both the matters may come up on the same day. I'll file my limited reply, my lord. But at least I want to bring this on record, my lord, because these,
You bring it on. Therefore, I'm saying, allowing you to file a reply. But I'm only also making it very clear what am I going to do. Therefore, initially, when he filed the review, I said, this is not a review, it's a clarification. And therefore, I allowed this to be used as a clarification. Review is not perfect. You take the ground also 87 Supreme Court, you cannot file clarification. This, and this was the counsel appearing on behalf of the respondent hearing submits that you would like to file a reply to the present application, wherein certain clarifications have been sought to the judgment and order dated 4/2026, passing application number 3832/2024. Taking into account the above, list this matter again on 29th, 30. So have it on the last day. 30. 30, no, 29. On 29/4/2026. The reply be filed on or before 23rd of April 2026. Even the word contempt one lists this contempt application with the calendar. Review petition number.
Item 5, my lord, we need some more time to file affidavit. Service part, qualify.
This one we have already filed affidavit.
Is it?
We have served it. Response number 7 appearing.
Yes.
Oh, this one. Why haven't you filed affidavit, Mr. Clerk?
My lord, because of the election process, my lord, all the members of the chief executive officer, including block level and Rapporteur level, are engaged, my lord. So after the vacation, my lord, I'll file.
Mr. Dr. the Learned Standing Council of the PNRD Department submits that a final opportunity may be granted to the PNRD Department to bring on the court stand by filing the affidavit. This matter again on 22nd of May 2026. Was a final opportunity granted to the PNRD Department. You are filed. You have not filed. Have you filed a affidavit? A final opportunity is granted to all the respondents to bring on the court their stand by filing their affidavits on or before 12th of May 2026. Liberty given to the commissioner to file reply. By state it fixed.
6 also same, my lord.
22/5 or 22/4?
22/5. 6 also same.
Yes, sir.
Same one.
Regarding service, yes.
Regarding five, the investment number 7,
Service complete. Service not complete. As per process, it is seen that has been delivered to the concerned. Okay, service being complete is the matter for admission on 22nd of May 2026. Final opportunity is granted to all the respondents to bring on record the stand by filing the affidavits on or before the 12th of May 2026, liberty given to the petitioner to file.
34 also same one.
Service? No. Here, service is not complete.
Fine.
34. You're not serious. Huh?
I thought 39, my lord.
You have not effected service.
Yes, we have filed our affidavit yesterday, my lord. It's not.
Tony,
Watch. Last page we seen, my lord.
who has signed it?
The respond number 7.
Who is it?
Ella Kandi Gau Panchat represented by his president.
Taking into account the affidavit of service to file by the petitioners.
Yesterday. We have filed affidavit yesterday.
2-4 or 7-4?
7.
Date is 2-4.
Writing, my lord.
Huh?
Yesterday.
Taking into account the affidavit of service which have been filed by the petitioner, a copy of which was handed over to this box in the course of the day. Service was effected upon the respondent of 7 by way of the field this form on 20/2026, taking into account above. It's both deals that the service upon the respondent number 7 is complete. Accordingly, lists this matter for admission on 22nd of May 2026. According to affidavit by 12, reply therein. Remove
7, my lord. What? This matter I have received instruction, I'll file it.
7 also.
Yes. Order no steps, it comes for order. No steps.
In respect of respondent number 7, my last 10 million, he has already submitted to color.
Very big. He to kamote ipin ko system eh.
Item 5.
Final opportunity, yeah.
Yes, I'll file.
Same thing.
File. Hello.
You find it?
The affidavit has come on record. Your lordship, I had been instructed to appear for the bank.
Ah. Tell me,
We'll file the Vakala number today. So far as affidavit, etc. are concerned from the bank, lots of the pleadings are already completed this month. Pleadings are already complete. Affidavit has already been filed by the bank. They have in fact filed additional affidavit also.
now, tell me, who is under control of the bank? Who is
Sure.
bank? Does it have it been elected to vote?
There is a board.
There's an elected board now. Now you don't have the 41-6 officer.
No.
Are you having the 41-6 officer? No.
No, lordship, it's not there.
So therefore,
Mention that in the service.
therefore, now the question is, the bank has to file the affidavit.
Affidavit is already there, lordship.
By
By the bank.
how?
Lordship, they had entered appearance in the initial stage.
Then?
Subsequently, they stopped appearing. The affidavit is from page 81 to 93.
What do they say?
Lordship, they were initially saying that they handed over possession, thereafter somebody else captured. But later they have come up with a clear instruction submission before this honorable court that we are not in a position to hand over the possession of the land. Reason being, there is an interim injunction from the learned civil court. Due to the
yes.
dispute
So
between that-
therefore I pass some order now for payment
Yes,
of money.
Lordship. Your lordship has passed the order dated 7/8/2024.
Yes.
And lordship 29/1/25.
Pray for 4 weeks time to file an additional affidavit because we have just received out of it
They're paying for? Who's
for
your
the bank,
senior?
Industrial Property Bank.
You have no senior.
I have.
Who?
Saurabh Dihinia. Saurabh Dihinia.
Okay. No, we are concerned, you have to file an additional, I'm not concerned with other thing. You file an additional affidavit in terms with the orders dated with 7/8/2024 and 17/9/2020.
Lordship may kindly indicate 29/1/2025 as well.
Twenty-one,
29/1/2020.
29/1.
The respondents were directed to seek instructions as to why interest should not be imposed.
Okay. Ms. So-and-so appears on behalf of the respondent number 1 and 2 pursuant to the justice service effective upon the respondent number 1 and 2. This court directs the respondent number 1 and 2 to file an additional affidavit providing details to the queries so made by this court in the orders dated 7/8/2024, 17/9/2024, and 29/1/2025. Full stop. This court further takes note of that the said affidavit be filed on or before 8th of May 2026. Full stop. List this matter for admission on 15th of May 2026.
Obliged.
Oh, you asked for time now.
Council actually eat out of discussion.
Okay, at the request of the learned counsel appearing on behalf of the petitioner, matters that adjourned to be listed on 22nd of May 2026. What is it?
Lordship. Lordship, here the issue is Lordship, matter pertains to Lordship, section 3H4 of the National Highway. My lord, the award was passed in the name of one Viseswar Borthakur, my lord. My lord, the petitioners as well as my lord, private respondent number 7 to 13, they are the legal heirs. Award was passed in the name of the Viseswar Borthakur. And my lord, thereafter, my lord, notices were issued by the Kala, that my lord,
What others? You are paying for?
7 to 13.
Who are they?
They are the, you know, of the legal heirs.
Of
We received the.
Yadav Borthakur.
We received the compulsion.
Huh?
We received the compulsion. We are the legal heirs of Sir Borthakur, your law.
Yadav Borthakur.
Viseswar
It's just a Borthakur.
Huh?
Viseswar Borthakur.
Ragini Borthakur, daughter of Yadav Borthakur. Mita Lohita Borthakur, wife of Dulal Borthakur. Madhav Borthakur, wife, son of Dulal Borthakur. Okay? These are with Borthakur. Wow. What is the fight amongst you? What is the fight?
My lord, my lord, Kala, my lord, instead of referring the matter to the court of the principal civil court of original jurisdiction, that is the district judge Golaghat, my lord, release the entire compensation amount in favor of my lord respondent number 730. And my lord, award was passed in the name of the assessor board. Then we are all the legal heirs. When the Kala lordship will find that at page 37, my lord, that is the award, my lord, that 3D notification, my lord.
Where?
My lord, may see my lord serial number 121. Their lordship will find 2125 AP3. My lord,
Lokeswar Bothakur.
Punakeswar Sharma Bothakur is the brother of Iseswar Sharma Bothakur. And my lord, Iseswar Sharma Bothakur. That Iseswar Sharma Bothakur, my lord,
Is the father of the petitioner.
father of the petitioners, and my lord, also of the legal heirs of my lord, the forefathers of my lord, other respondent number, my lord, 7 to 13. And I have also enclosed the next of kin.
So what has happened is some of the brothers, some of them, who is Pradeep Sharma?
Today, Bothakur.
Pradeep Sharma. All of you are brother sister.
Oh, my lord.
Or heirs of brother sister.
Yes, yes, sir.
Now the respondent number 7 to 13 have got the money. 7 to
the money.
17.
Apart from,
Wait me. My lord, I have prepared the family tree, man, of Iseswar Bothakur, my lord. That page number 25. There is the family tree of Iseswar Bothakur, my lord. That my lord, Ratul Bothakur, petitioner number 1, Aforesaid Bothakur, petitioner number 2, Hina Bothakur, petitioner number 3.
Oh, got it, got it. So therefore these are people. Now what has happened? Yeah.
Claim for 3.
So the respondent number 7 to 13 has taken the money.
Yes, the money has been released in favor of them. My lord,
Now what do you want?
My lord, I pray for my lord, pass a direction.
Did you file an application under 3H4?
Yes, yes.
When?
My lord, it was filed on my lord, 13/12/2024,
Where?
page 52.
Page?
52.
Ah.
Page 52.
Now what has happened?
My lord, prior to that, my lord, may have.
So what has happened to this?
My lord, now, my lord, the money has been, my lord, released, my lord, in their favor.
So what should we do?
My lord, my prayer is that, my lord may pass a direction to refer the matter to the court of the principal civil judge of original jurisdiction. And also, I pray for recovery of that amount and.
Why?
Paid.
Let them put it in the fixed deposit, earn the interest.
Your lordship, in this case, your lordship, application was filed on 13/12/24 and money was already released on 26/3/24. Money was released on 26/3/24.
26,
3/24.
3 to 2023.
Yes.
And petition
And
filed
application was filed on 13/12/24.
13/12/2024. But later on.
Much later on.
Now this.
And in between, your lordship, they also filed a civil suit. And that civil suit, he withdrew with liberty to file a case. And everything suppressed in the writ petition.
My lord, in reply to that, my lord, may kindly see, my lord, page 39. Page 39. My lord. That was the notice issued by Kala to participate in the hearing. Because before disbursement. And there, my lord.
When did you first raise the objection?
On the very first day, man.
When?
On 1/4/2012, when on 8/4/2022, man.
8/4/2022. Where is your objection?
My lord,
When did you appear?
that is the difficult thing. Because, my lord, we have placed the, my lord, my lord, the next of kin certificate before them.
So here the notice was issued to all of you.
Yes, yes.
Then why didn't you go there?
No, my lord, we have participated.
Then what happened?
We have participated, my lord. We have placed.
So if you have participated, there must have been some order passed.
Yes, my lord.
Where is that order?
My lord, because we have prayed for the documents, my lord.
I'm asking you, where is the order passed to release? when you have been asked to hear, where's the order for release?
My lord, in the last date, my lord, Lordship has directed the Kala to file an affidavit. And Kala has filed an affidavit, my lord. And that says, my lord, paragraph 4, my lord, kindly see, my lord, the
Respondent number 6.
respondent number 6. Paragraph 4, my lord. Paragraph 4 of their affidavit, my lord. Lordship got it? The DO deponent gets to state that as per report of the circle officer, Daga Revenue Circle, the land in question which was acquired was found to be in possession of respondent number 7 to 13. They were enjoying undisturbed and uninterrupted possession over the land in question acquired.
Annual patta land.
Annual patta
Annual
land.
patta
So
land.
what right you
No, no,
have?
my lord, it was, my lord, no partition, nothing of that.
Not necessary.
Because, my lord, here, my
Go
lord,
and fight it out there. No right. You were not in occupation.
no, my lord, my lord, in a,
Okay.
in a, my lord, ancestral property, my lord.
Okay.
Possession of
I
one,
think,
my lord, possession of one, my lord. No, first, my lord, possession.
Annual patta land. What right? No, it's not heritable.
No, but my lord, they don't have any possession, my lord.
So they were in possession. That is what the circle officer said. This person.
No, my
has-
lord, but my lord, may kindly see one
Were you
thing,
in
my lord.
possession?
My lord, kindly see.
Were you in possession?
My lord, we are in possession, my lord.
When?
My lord, it
Show
was,
me that you were in possession of that land.
my lord, it's an ancestral land, man.
Ancestral land, annual patta, no ancestral.
No, but my lord.
Concept of
kindly see, my lord.
annuality from year to year.
No. But my lord, there was no notice of that sort, my lord, to effect that, my lord, they were in, it was not continuing. my lord.
Not necessary.
No, but my lord may kindly see, my lord, whether my lord Kala can modify an award.
Go there. We do
My
what
lord,
we only say that let him go there, asking the competent authority to refer the matter, the application to the court, and the court says he will take care of it. Why should we trouble
that
us?
and my lord may kindly appreciate one thing, in
Spend the
between
entire
the
money
same
and then
parties,
say that we are bankrupt.
my lord, in between the same parties. my lord.
Moreover, your lordship, it is also open for him.
You say I'm bankrupt, no money.
No, my lord, in the civil court, my lord, they have raised an objection, my lord, that this suit is not maintainable. Because there, my lord, we have filed the suit, my lord, it was wrongly filed, my lord, it was paid for, my lord, right title interest. my lord. Whereas at that moment, my lord, land was already acquired by, my lord, government of India. So they have pointed out that this suit is not maintainable and we have also realized our defect.
Heard Mr. M. Dr. the learned counsel appearing on behalf of the petitioner. Mr. Union. Mr. So-and-so appears on behalf of the responding number 1.
Yesterday, my lord, we have filed our affidavit, my lord, that was not on record.
Alket Alukya appears on behalf of the respondent number 3 and 4. The access Roy appears on behalf of respondent number 2, 5 and 6. And Mr. Endra appears on behalf of the respondent number
7 to 13.
7 to 13.
Your lordship, NN.
NN. The petitioner hearing is agreed, the petitioner's hearing are agreed by the action on the part of the respondent number 6 to permit, to allow, to in disbursing the amount of compensation, in disbursing the entire compensation of rupees 81,74,365 to the respondent number 7 to 13 by disregarding the rights of the petitioner in respect to the said land. The petitioner also had submitted an application before the respondent number 6 on 13 to 2024, and the same having not been considered
12, 13, 12.
13, 12, 12, nah?
12,
12.
12.
13/12/2024, and the same having not been considered, the petitioners have approached this court by filing the present writ petition. From the materials on record, it is seen that a plot of land at measuring how much?
Another one. 1/11.
1/11 lecha, covered by annual patta number 3, covered by tag number 2125 of annual patta number 3, situated at Dergaon under Moza, Dergaon, was acquired under the National Highways Act 1956 for widening and four-laning of the National Highway 37. Full stop. The petitioners herein claim that they are the legal representatives of late Indesor Assessor Sharma Bhattakur. Assessor Bhattakur, like the respondent number 7 to 13. However, the respondent number 6 have disbursed the entire compensation to the respondent number 7 to 13. And it is under such circumstances the petitioner has approached this court, petition. Mr. N.N.J. appearing on behalf of the respondent number 7 to 13 submits that the compensation was awarded on 26/3/2023. Disbursed on 26/3/2023. And the petitioners have raised such objection by filing the representation only on 13/12/2024. This court have also taken note of the affidavit which have been filed by the respondent number 6.
May I say?
No, no.
No, my lord, if the record
Mr.
for- my lord,
No, Mr.
everything will be clear, my lord. We have filed our objection at the very inception, my lord.
It is his submission. Why do you disturb? I am imposing a cost of 50,000. Wait, we have the habit of disturbing this court. And this imposing a cost upon 50,000 from you. Until the cost is not being paid by you, you won't be allowed to practice. Nothing at the end. This court also takes note of the affidavit filed by the respondent number 6, wherein it is categorically mentioned that the land which was acquired was found under the possession of the respondent number 7 to 13. And taking into account that the land was taking into account that the rights of the respondent number 7 to 13 were that of annual patta holder and not landholder. The compensation was paid to the respondent number 7 to 13 by the respondent number 6 in terms with section 3H3 of the National Highways Act 1956. Mr. M. Doctor, the learned counsel appearing on behalf of the petitioner, however, submitted that though it is being mentioned that on 13/12/2024, the petitioner had submitted the application under section 3H4, but immediately upon receipt of the notice issued by the respondent number 6, the petitioners had appeared before the said authority and claimed their right over the said land. The learned counsel further submitted that there being disputes under section, there being dispute as regards the entitlement as well as the apportionment of the compensation. The respondent number 6 had no jurisdiction to decide the quantum of the entitlement as well as the apportionment of the compensation. And it was the duty on the part of the respondent number 6 to make the reference in terms with section 384 of the National Highways Act 1956. This court have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. A perusal of section 3H of the National Highways Act 1956 would show that in terms with subsection 1 of section 3H, upon the authority, the central government shall deposit the amount before the competent authority before taking amount of compensation determined before the competent authority before taking over of the possession. A further perusal of section 3H3 shows that when there are no disputes, the competent authority would have the power to disburse the said amount to the persons who are entitled to receive the compensation. Section 3H4 further makes it very clear that in the circumstance there are disputes, as regards entitlement and or apportionment of the amount, the said dispute what is required to be referred to the for a decision of the principal civil court of original jurisdiction within the limit of which jurisdiction the land is situated. In the instant case, as the land was situated within the jurisdiction of the district and session judge Gauhati, the competent authority for land acquisition, that is the respondent number 6, instead of disbursing the amount, ought to have referred the said dispute to the decision of the learned district and session judge Golaghat. This court also takes note of that the petitioner have also submitted an application in terms with section 384 of the National Highways Act 2024 to 2015, 1956 on 13/12/2024. And the respondent number 6 then also have not taken any steps in that regard. Considering the above, it is the opinion of this court. This court therefore disposes of the instant petition with the following observations and directions. The respondent number 6 is directed to act upon the representations so submitted by the petitioner on 13/12/2024 and refer the said decision and make a reference of the dispute as regards the entitlement and or apportionment of the compensation between the petitioners hearing as well as the private respondents to the decision of the learned district and session judge Golaghat. The same be done within a period of 15 days from the date a certified copy of the present order is served on the respondent number 6. This court further observed that though the respondents hearing, the private respondents hearing have received the said compensation, as was disbursed by the respondent number 6, but the entitlement of the respondent number 6, of the private respondents hearing, as well as the petitioner, shall be subject to such decision of the learned district and session judge Golaghat. This goes further, taking into account the unnecessary disturbance caused by the learned counsel for the petitioner during the course of the hearing, imposes a cost of 50,000 to be deposited by the learned counsel before the registry of this court within 15 days from today. And the registry shall, on the basis of the said amount, shall disburse it to the legal services authority.
Lord, it will not. Wait, my lord, actually, my lord, it was my mistake. In future, I undertake before your lordship, my lord, it will not happen. I apologize.
I put it on the order that you are going to give an undertaking.
My lord, I will not, my lord, I make
You
any.
have to give an undertaking, filing affidavit. Because this is your repeated you are doing. This is not the first time. That day also, when I was passing the order, you keep on disturbed when I'm passing the order.
Lord, it will not happen.
Next time you do one thing, next time onwards, you write the judgment and come and I'll sign it.
Lord, I will not. My lord.
No, you dictate. Next time, whenever the matter comes up, you dictate. Is this the way how you appear before the court?
I apologize, my lord, it's my mistake, my lord, and it will not happen in future.
You give an undertaking. File an affidavit. I put it on the order. So next time it is there on the order that you are not going to disturb this type of thing. File an undertaking before the area and then paste it in all the court notice board.
Your lordship, this is.
Next time onwards, if it happens, then next time you do it, just inform me. Shut him down. Must.
Okay.
Mr. Panging, we put this matter along with the other petition. I placed the matter before the Chief Justice. Let this
My
matter
lord.
also go along with that.
My lord.
Okay.
My lord. My lord.
Because there the main issue is being looked into. Your issue also will be decided there.
My lord.
Yeah, other order to do. That is it.
Obliged.
Yeah.
Respondent number 6 has filed his affidavit. I would like to file a reply to that. Respondent number 3, 4, and 5 are yet to file, my lord. The municipal board matter. I'm alleging violation of the building norms, my lord. And so far as 6 is concerned, I would like to file a reply to that, my lord. 3, 4, 5, Madam Bhattacharya had appeared. I think she has.
What is the illegal construction done by him?
Illegal construction, first of all, madam, my first submission is that it was done without the permission, that there was no valid permission because the permission expired. And secondly, the side setbacks have not been maintained. And in fact, my lord, now, though the G+2 was being permitted, now he has concerned of G+4, my lord. He has filed the affidavit, I have to file a reply to that. And my lord, in fact, I had earlier approached this honorable court, my lord. And my lord, the matter was remanded back to the authorities. To the authorities, my lord.
Mr. Biswas, tell me, you are appearing for respondent number 6.
And with the permission of the municipal board, we have constructed
Why haven't you enclosed the permission?
a permission. Permission I have not. I will, but I mentioned, my lord, that with the permission it was extended. It was expired, again extended for another 2
But
years.
why you have not enclosed the permission?
My lord,
If
actually,
it is such a magnitude that this affidavit, we will therefore say that there is no permission.
no, that
When there is a document, the document has to be taken. This is an oral evidence. Oral evidence cannot be
Right.
taken. We place it as if section 91 of the Evidence Act. We cannot look into this. So therefore there is no permission.
my lord,
Yes.
with the additional
or better.
affidavit, I will file.
You demolish the building. Well, who appears for the Borpeta municipal?
My lord, Madam Bhattacharya appeared, M. Bhattacharya, my lord.
Services. Huh?
Sir, Bhattacharya, my lord, M.
Hello,
Bhattacharya.
we direct the Borpeta municipal board to demolish it. We have not enclosed the permission.
My lord, we have got the permission. Kindly
You
give
don't
me the,
have.
my lord, kindly give me
You
the
don't have.
opportunity.
You
I'll
why?
file an additional affidavit.
Mr. Biswas, isn't it that something trying to clever with the court by not enclosing the permission.
Sir, but I'm sorry for
It
it.
appears,
I'll file.
it
Kindly
appears
give me an
because of
opportunity.
the fact that it is being filed by a counsel out here and he doesn't know that it is required that this
But
is
I've
the
got
most
a-
pertinent document.
With all bona fide, my lord, I have
There's no
some-
bona fide. This is absolute malafide on your
my-
part.
Kindly help me, my lord.
Then when your
kindly give me an
entire
opportunity within-
entire affidavit is based upon this particular document, which you say that has been extended on 26/7/2024, why should we look into it? We may say that this is on the basis of that we have not enclosed. We
Sir,
say
give
that
me
there
an
is no
opportunity,
permission.
I'll file it. Kindly give me an opportunity. I'll file it. Again, with an additional affidavit, I'll file. Kindly give me.
The affidavit filed by the respondent number 6 mentions about some permission being granted to the respondent number 6 for construction of the building. Full stop. However, surprisingly, the said permission, which ought to have been brought on record by filing an affidavit, have not been placed. Full stop. This court have also taken note of that in spite of service being complete upon the respondent numbers 4 and 5, they have not chosen to appear. Full stop.
My lord, name has not been shown. That is the problem in the call.
How will the name be shown if they don't file the wakalatnama?
Last again she appeared. But then she appeared last again. That's the last one.
No.
She short time.
Her name is not shown.
Not sure.
Okay.
For voting.
Okay. Gauhati
Oh, her health is
have
not
not
good, madam.
brought on record the said document. Full stop. Taking into account the said, the said affidavit so filed by the respondent number 6 cannot be taken into account as stating that the respondent number 6 has a permission for construction of the building. In absence of the documentary evidence in that regard being placed before this court. Mr. S. Biswas, appearing on behalf of the respondent number 6, submits that the said affidavit would be filed, that he would file an additional affidavit in that regard. Full stop. List this matter again on 24/2026. In the meantime, the additional affidavit, a final opportunity is being granted to file the additional affidavit. Failure to do so, it shall be construed that there is no such document as mentioned in the affidavit filed by the respondent number 6. The registry shall show the name of Ms. Bhattacharjee appearing on behalf of the respondent number 4 and 5. What is this?
Requisition of land.
But here I could file an affidavit today on behalf of the respondent number 3.
Oh, today we were supposed to state, no? We state.
I have filed an affidavit.
That is not on record. You never asked for calling for that.
But I could file it at around 12 now.
So you have not
I-
asked for calling for
I
it.
have an extra
Why
copy.
should we look into this type
I
of
have an extra
activity?
copy.
What is your power?
But in fact, this is in the process, my lord. Some land has been already dedication and we have also acquisition.
Where is the gazetted notification?
Acquisition we have done, that notification kindly come to page 258. my lord. Some
Eight?
page 250 and Annexure 3. Some portion of the land we have already acquired under section 6. my lord. 86 data 4 kata 14.41.
No, where is the requisition
The
notification?
requisition we have annexed, my lord.
Where is the gazetted notification?
Gazetted copy I did not.
Oh, that means you cannot exercise 6 without a requisition.
But it is
And the
there-
requisition is not gazetted. There is no valid exercise of power.
It is there, my lord, 241. my lord, because of the page 241 is the.
It is only in Form B.
Yes, my lord.
Then
That I have, my lord, that I have.
where?
We have that law.
You don't have,
No, it
you
was.
have not enclosed it.
was-
No.
In fact, Mullah, in
This,
the
this type
process-
of notices would not do.
Mullah, in the process, requisition has been done. Some land, whatever is not required, that has been
Have you paid
de-requisited.
the compensation?
But-
Have you paid the compensation?
No, compensation.
Why? Have you determined the compensation?
Mullah, in fact, because of the ongoing election process, Mullah, it is.
That means if somebody's rights will take over like this.
No, they will get.
Because
whatever-
of the elections coming, the person should be deprived of his possession of his rights over the land.
whatever-
Sorry,
Kindly see,
this type of action is not at all contemplated.
Mullah, kindly see.
When is the section 3 notice being issued?
It was in the month of July 2025.
And then,
Then, Mullah, de-requisition, some land has already been de-requisition on 4.
have you paid them the compensation for the requisition?
It will be paid.
When?
It, Mullah, Lordship, 1 month time is required to complete the entire process because already acquisition we have done in the month, some land we have already acquired. And whatever land is required, Mullah, that will be.
Even a copy of this document is not forwarded to the gazetted, no, to the government of press for publishing in the gazette. See, nothing is there. Section 3. You have taken the law on your own hands. This is not how you do it. Illegal.
Mullah, requisition has been done in respect of 235 bighas. The requisition has already been done, Mullah, in respect of some. And
How much?
the requisition we have already done, page number 256. Kindly see 35 bigha, 3 katha, 4 lesa already de-requisition. Out of the total land.
Out of 248 bighas, you have only done acquisition of 85 bighas.
86 bigha.
So remaining you have returning it.
No. That because they have filed objection, that objection hearing is going on. We are completing the
Objection hearing for?
Mullah, after the requisition, some of the parties they have filed objection. That hearing was going on, some has been already been Mullah, acquired. And in rest of the portions, Mullah, in the affidavit, I have said that hearing process could not be completed because of in the meantime, the election process has come. Within a month, Mullah, that process.
You
will
have
be
taken
over
the possession.
for the purpose of ascertaining, Mullah, the survey and all these things.
Have you taken the possession?
Mullah, kindly see, Mullah, kindly come to my affidavit. Mullah.
No. This type of action is not contemplated.
At that point of time, in the month of July, water logging was there. These are agricultural land, Mullah. Because of water logging, that could not be done. That process is going on. Objection have been, they have filed objection. Objections were being heard, Mullah. Altogether, kindly see, lot of persons are there. The objections are being heard and the
It has been submitted on behalf of the respondents. Pursuant to the order submitted by Mr. D. Nath, the learned senior government advocate. That pursuant to the order passed by this court on 33/2026, an affidavit has been filed. A copy of such affidavit have been placed, although the said copy of the affidavit have been filed during the course of the day, but a copy thereof was placed before this court during the course of the hearing. A perusal of the said affidavit do not reveal that there was any gazetted, any notice was published under section 3 in the official gazette. Further to that, the requisition was carried out in respect to a plot of land at measuring 248 bighas, 3 kathas, 8.5 lechas of village Mirzapur under Ramsoroni Moza. How much?
257 bigha.
257
Seven.
bighas. Where is it? Boundary?
Page number 241.
241.
257 bighas, 0 katha, 9.5 lechas of village so and so under Ramsoroni Moza in the district of Kamrup Metro Assam. It is also seen that in pursuance thereto, a notification has been issued under section 6 for acquisition of 86 bighas, kathas, 14.4.1 lechas. The question, however, arises as to whether the person's land which have been requisitioned have been done in terms with Section 3 of the Assam Land Requisition and Acquisition Act 1964, more particularly when it is the mandate that such notifications are required to be published in an official gazette. Apart from that, a question arises as to whether the person whose land have been acquired under Section 6 in terms with the notification dated 1st of September 2025 have been paid the compensation.
But our lands have not been acquired.
Have been paid the compensation. Inasmuch as upon issuance of a notification under Section 6, the land vests upon the state by operation of law. An affidavit in that regard be placed by the state on the next date without fail. First of list this matter again on 24th of April 2026 for further deliberation.
Is court has filed an affidavit of provision inspector. And apart from this, my lord, there is a process going on, my lord. I have offered 20 lakh one-time settlement.
Huh?
20 lakh one-time settlement, by the petitioner's file to the bank, my.
Then
So, my lord, let me proceed after,
what do you want here?
my lord. My bank account was blocked, my lord. Now, my lord, there is outstanding, petitioner availed 32 lakh loan facility from the Punjab National Bank. Now, my lord, with pendency of the petition, my lord, the petitioner approached the authority, my lord, for one-time settlement of 20 lakh, my lord, which has been denied, my lord, and asked to submit a fresh proposal, my lord.
You have filed the affidavit?
Yes, they have filed.
Your Lordship, I have filed yesterday. It has not come in the record.
You? It has been submitted by the councils appearing on behalf of the State Bank of India as well as the Punjab National Bank that affidavits have been filed on 7/4/2026. However, the same are not on record. List this matter again on 6th of May 2026. In the meantime, petitioner would be at liberty to file reply. The registry shall bring on record such affidavit in opposition which have been already filed by the State Bank of India and the Punjab National Bank. Yes, what is this?
Look, that challenge is just the annexure 3. 10-11 to 1. By circular officer to the police in here. Page 16.
What is your case?
My lord, by this, my lord, notice, I have been restrained into intent to minor by this notice. And this is
10/11/2025.
10-11-2025.
Where is that order?
Issued by the circle officer addressing the officer in charge.
Where?
That is page 16 and annexure 3.
You got a stay?
No.
Then
I am for the inquiry into the Chester matter 5 to 60, and I have filed our application with him.
You are in possession.
No, man.
Nobody is in
Nobody
possession.
in positions, and police has restrained us and others persons to enter into them. Because by this notice.
But how is the circle
Well-
officer exercising this type of jurisdiction?
You know,
Isn't it to be done by way of an attachment by way of the executive magistrate? What is this type of exercise done by the circle officer?
apprehending law and order. Supposed
What do you mean? Law and order, the circle officer has no business out there. It has to be done through the executive magistrate.
only instruction
We set aside these type of orders. You take an action, initiate let the police take an action in terms of that. What will be the new provision now?
164, 164 BNSS. Under that.
120?
6 and 164 BNSS.
No, you have to. 126 is 107. Senate counsel appearing on behalf of the petitioner submits that such exercise of jurisdiction is foreign to the settled principles of law, inasmuch as, for the purpose of attachment of the land, proceedings either has to be before the civil court or has to be based upon orders passed under section 128 or oblique 164, 126 oblique 164 of the BNSS system. Nothing would be shown that the respondent number 3. This court have perused the affidavit filed by the respondent number 3. Wherein reasons have been assigned as to why the notice oblique letter dated 10/11/2025 was issued. The ground on which the concerned circle, the respondent number 3 had issued the communication is on the ground that the land in question is in a non-cadastral village. And only after survey, the actual owner of the land can be determined. This court has given an anxious consideration to the issue involved in the instant proceedings. And the said order, and in the opinion of this order, in the opinion of this court, the said order dated 10/11/2025 is an order passed by the respondent number 3 without jurisdiction and authority, inasmuch as the said order is an order in the form of an attachment of the said land, which can either be done by the civil court or by the executive magistrate. No? Executive magistrate in terms with section 126 oblique 164 of the BNSS, considering the fact that the impugned order dated 10/11/2025 issued by the circle officer is without jurisdiction and authority. The same order is set aside and quashed. It is, however, observed that setting aside the order dated 10/11/2025 shall not preclude the respondents herein to initiate appropriate proceedings under law as permissible.
We have filed our affidavit now.
You filed?
Yes.
Lordship, we will file our rejoinder. We just need 2 weeks time.
The counsel appearing on behalf of the petitioner submits that they would like to file a reply to the affidavit in opposition filed by the respondent numbers 1 and 2. Yes. Accordingly, list this matter on 8th of May 2026. In the meantime, the reply be filed.
Petitioner's son, namely Sadiq Islam, was died in electrical content and
This report of the chief electoral, have the affidavit be filed?
Yes,
filed yesterday.
file.
What is the report?
My lord, report shows that the fault is on the part of the, my lord, owner of the land.
Okay, the affidavit is not on record. It has been submitted by Mr. B.J. Talukdar and his senior counsel appearing on behalf of the chief electrical inspector that the affidavit has been filed on 7/4/2026, containing the electrical accident report. The said affidavit, however, is not on record, and accordingly list this matter again on 15th of May 2026. In the meantime, the registry shall bring on record the said report. Petitioner would be at liberty to file any reply there against. None appears on behalf of the parties on call. Accordingly, list the matter immediately to be listed after phone. This so and so appears for respondent number 1. None appears on behalf of the petitioner on call. So and so appears for the respondent number 1. Mr. B.J. Talukdar, assisted by so and so, appears for respondent number 2 and 3. This is the matter of the 4 weeks. Shahjahan Ali. What is this name change? Yes, what is this?
My lord, lordship. This case, my lord, we have sent the affidavit for verdict. We'll be filing within the day. Affidavit has been sent for.
Mr. B.J. Talukdar, the senior counsel appearing on behalf of the respondents, submits respondent number 2, 3, and 4, submits that the affidavit has been set for vetting and would be filed within 3 weeks. List the matter again on 22nd of May 2026. Affidavit be filed on or before 15th of May 2026. What is this?
We're challenging assessment procedure initiated under the Income Tax Act, Lordship.
Which year?
2018-19, Lordship.
1819. Have you filed the affidavit?
no, Lordship, similar issue is pending before the Supreme Court. Similar issue is pending before the Supreme Court, Lordship.
What issue?
The 148 notice that issuing the 148 their issue, and on the same issue they filed a different 2 similar writ petitions which are pending. But the assessment here are different. So kindly take, better maybe take together, Lordship.
No, 148 notice, how can you challenge it now? When did the 148A come in? Did you get a 148A notice?
Yes, Lordship.
Then how can you challenge a 148 without challenging 148AD order?
140. Lordship may take it up on a different date, Lordship.
The counsel appearing on behalf of the petitioner is not prepared. Accordingly, matters stand adjourned to be listed after 3 weeks.
Lordship, there's an interim order.
What interim order? You are not prepared.
There's an interim.
Without being interim order, how do I pass an order? You have to be, you know, Mr. Day, be very
Yes,
careful when the
they were
matter
describing
comes up.
affidavit, Lordship. There's a counsel who's appeared from
through video conferencing on the previous date, Lordship. So I'm not fully prepared today, Lordship.
So
Kindly,
we can't run to an extension. Not satisfied?
please take it up immediately after the vacation.
Okay, release the matter at the request of the learning counsel for the petitioner, release the matter on 4th of May.
Doing my kind.
No. You do whatever you feel like. I'm going to extend in 10 months. Unless you are prepared.
Lordship, 148A notice is there.
So, you are not challenging the 148A order.
148A is is by an individual, Lordship, and not through the faceless mode which is required under
Huh?
the
148A notices?
not by someone who's not through the faceless procedure prescribed under the income tax.
Ah.
So that is not permissible, Lordship, as per the new scheme.
No, I take it. Yes, what is this? Challenge to the petition is against the 148 notice issued for the year 18. The challenge is made towards the letter dated and consequent. The proceeding has been initiated in contravention of the law and there is the jurisdiction. He has relied on the judgment of the coordinate bench wherein the aspect that the proceeding under one has to be automated and in a faceless manner has been highlighted. What? What is this? Oh, no. You are challenging a 148 notice.
Yes, Lordship.
You file your reply. 148 notice, issue a notice on the 38th. Let us see 148 notice. Where is it? We cannot allow this type of thing. Notice on the 148A notice has been given. Then you have filed a reply. Then order has been passed. Order must have been passed. Supreme Court precedent. Yes, notice under remand. Where's the order? I have been informed that a search was initiated under 132 of so and so. I am satisfied with the approval of the principal so and so pertains to or to any information relating that being in the region of so and so remand. I therefore propose to assess or reassess the remand for 18 and 19 and I hereby require you to furnish within 3 months from the end of the window till a return in the period of so and so. Please note that any return required to be furnished by the demand. Then, what is wrong? Intimation to the SSC for completion of assessment under 144B. Has been selected and completed of this list. And what is your case? Reply to the notice under 117 under 153. This is the notice. Like no order under remand has been passed by the assessing of the disposing of the action recording reasons for under 140. Instead, a notice was mechanically issued a year without complying with the mandate of INA. This is disposed of by INA. A search was conducted. Search the SSC is satisfied with the prior approval of the sworn floor of the commissioner that the demand the execution shall be deemed to have information which suggests that the information is the demand the following subsection remand. The search has been initiated under section 132 or requisition is made under section 132. The survey is conducted under section before it was been accepted the provision to like this immediately time for this one issuing for notice on the so okay. Got it. Notice
There are similar orders also. Ma'am.
And similar orders, I don't go by similar orders. My question is here. Here is a case, what is your ground? You have to go on the ground that you are challenging the reasons. There's no reasons to believe. That is the only ground you have.
Oh, Lordship, the primary ground is that it has to be through a faceless procedure, but if your Lordship looks at the one
No,
point.
Mr. Counsel, no. See, in 2021, 148A came in. Earlier to that, 148 was the proceedings by which the assessment proceedings was initiated. Now, by bringing into account 148 capital A chance is being given that before initiation of a 148 notice, there is a requirement for giving a hearing. This hearing is being given to you, and you look, made your reply, everything. Then all of a sudden, 148 notice was issued. You say that without the order under 148 AD, so there is no order of 148 AD. How could you do it? So then they say that when there is a search being conducted under 132 and something is being found out, and this is done prior to the year 2024, then the provisions of 147 to 151, which existed prior to this particular coming on 2021, would apply. Therefore, they issue the notice under 148. Now, the question you can challenge is there was no reasons to believe. Because to have the reasons to believe is a condition to see them. This is your case. Affidavit?
Some time to find out.
You are helping them. Then why you are not filing affidavit?
Lordship, their order, similar matter,
Huh?
the same issue is pending before the Supreme Court.
So what? The respondents have not filed any affidavit in pursuance to notice being issued by this court on 11/3/2026. Final opportunity. A final opportunity is granted to the respondents to bring on record its stand by filing the affidavit on or before 6th of May 2026. List the matter again on 20 May 2026. Interim order passed earlier shall continue till then.
Repeat the Lordship. The matter pertains to payment of adequate compensation towards land acquisition. Let's come to the second.
Lordship, instructions are awaited, your Lordship, but my submission is, there is alternative remedy, Lordship, because estimate already submitted by the deputy commissioner is accepted by them, and again,
We passed the award.
award, Lordship,
Has the award been passed?
Lordship, the estimate that was given was amounting to 36 crore. An odd amount. We are seeking for 8 crore, 21 lakhs, 100. The detailed calculation is at 20.
This acquisition is made by whom?
By the water resources for construction of a T dike.
No, but where's the award?
Not clear from the document, Your Lordship. I have not received any instruction.
Madam, why don't we pass the award?
Your Lordship, Deputy
Yes, why you
Commissioner,
are not passing the award? SS Roy was there. You don't come in between now. You have nothing, don't file affidavit, nothing to the effect. First of all, have you passed an award? If you have passed the award, it is well. Why should we look into this? They have reduced the sport into a office of the collector. Do you think so? Then Mr. B.J. Talukdar, Senior Counsel, appearing on behalf of the respondent number respondent number 2 shall obtain instruction as to whether the award has been passed in LA case number in connection with LA case number
8 of 2020.
8/2024 on the next day. This is the matter on 4th of May 2026 for instruction.
I would propose.
Let's have it on 6th of May.
May please, Your Lordship. Lordship, this is an account freezing case, in which my respective prayer was that my account has been frozen without any notice. Lordship, my account has been frozen without any notice. Lordship, the respondent number 2 is.
Your account has been frozen.
Yes, Lordship. Lordship, my humble submission is that the respondent number 2 has filed its reply today, stating some evidence that the old amount was only 990 rupees. However, there are certain unusual activities with regard to me in the account. So, Lordship, I need to seek instructions because I have received the reply today only. It has been served to me.
Where is the affidavit?
Lordship, it has been filed today only, Lordship. It's not in the record, Lordship.
We have a copy.
I have copy here, Lordship.
That big one.
Yes, sir.
Yes, Lordship, I need to.
Lordship,
It has been submitted that the respondent number 2 has filed an affidavit in opposition. However, the same is not on record. The learned counsel appearing on behalf of the petitioner submits that he would like to file a reply. List this matter again on 13th of May 2026. In the meantime, the reply be filed on or before 11th May 2026.
May please, Your Lordship. May please, Your Lordship. Lordship, on last occasion, one instruction was sought for us regarding.
Oh, these matters.
Yes,
Yes, Lord.
You are paying for comment.
Lordship, we have received a letter from the concerned circle officer into the concerned staff has engaged in election duty. One last opportunity to thank them. We engage in election duty.
There are similar matters.
Yes,
Which are the
sir.
items?
24 to 28, Your Lordship, similar matter.
24 to 28 all होते हैं करीब.
May I put it?
Mr. So-and-so who appears on behalf of the respondent numbers
2 and 0.
2 and 3 submits that some more time can be granted to the authorities for obtaining the authorities to place the necessary instructions as have been sought for by this court. Was taken a court. The reason cited is on account of the ensuring elections to the Legislative Assembly of the state of Assam, which accordingly lists this matter on 13th of May 2026. In the meantime, the district commissioner is a party.
Yes, your
The
lordship.
district commissioner of Kamrup Metro is directed to bring on record its stand by filing a common affidavit in respect to all the 4 petitions. In all the 4 or 5 petitions, 5,
5 read petition. lordship.
all the 5 petitions. Was the affidavit be filed on or before 8th of May 2026?
Much of it, your lordship.
Relating to service tax, the preferred appeal. Initially, that was dropped. Director Department paper revision. Then revision was allowed in favor of the department.
And revision was done without hearing as well.
Huh?
That revision was done without affording any opportunity of hearing. And the SOPOS was issued. Original order was passed, dropping the SOPOS, that's it. Then the order was reviewed, but we are not heard. That's it, the revision. And thereafter, appeal was filed by the same authority which had passed the original order also. This letter before filing of the affidavit by the other.
What order is this? 9/1/2000?
23, page 192.
Okay. What is the direction given? Why this section does not contain the entire lecture? What is this document? So what is wrong with the order?
Lordship,
What is wrong with the order?
Lordship, the order in original was passed, allowing, dropping the SOPOS notice which was issued, Lordship. Thereafter, a review of the order was done. We were not
Review or revision?
reviews.
Revision by the department.
Revision was done, then
Revision was done, Lordship.
It was allowed in favor of the
And
department.
then again, it was allowed in favor of the department, Lordship. And but we were not heard, Lordship. No notice was ever issued regarding the revision also. Lordship, this mentions this is vanishing, Lordship.
then
In the preferred appeal was dismissed.
Appeal was
was the revision heard without notice?
yes, Lordship.
That act of instruction of
Huh?
today, Lordship, we have received affidavit on way. We'll file today itself.
Mr. S.C. Kyle, the learning counsel appearing on this, because you see, there is a blanket stay which is being granted. This is not what we can't grant a blanket stay like this.
Let the appeal will be filed on the next.
Huh?
Just the you can hear it. Lordship, you can do the hearing, Lordship. Let them file the affidavit, Lordship, after filing the affidavit.
But I'm not inclined to extend the interim order.
But Lordship,
Why should I pay money?
because Lordship, they
will
were
the
supposed to
government
file the affidavit on the last day only.
How will the government survive?
The first order itself, they were supposed to find the affidavit, Lordship.
They don't buy. It's a different thing. Only question is what? What is the only question left?
Appeal lies to the CSET.
Huh?
Under 86 of the Finance Act, appeal lies to the CSET.
Why should we look into it?
But there's a case of natural justice violation also. That is why we are reporting.
Natural violation, then why didn't you come against the revision order? Why did you go and file an appeal? And when you file an appeal, the appeal lies to the higher authority. Statutory, you have already gone into that pipeline. Now you want to come out in between. You should have gone and moved the CCAT. CSAT. So,
Let
why
it be
should
taken
we
out just after
entertain?
vacation, Lordship.
Huh?
Let it be taken out just after vacation, Lordship.
No interim of the extension. Huh?
Can you, Lordship?
It is
Until then,
no.
until next date, Lordship. Fixed date may be given until next date, Lordship. Can you, Lordship?
Very difficult.
Can you, Lordship? Can you, Lordship?
The counsel appearing, Mr. S.C. Kyle, the counsel appearing on behalf of the petition respondent submits that the affidavit on behalf of the respondents would be filed on or before 24/2026. Taking into account the above, leaves this matter again on 24/4/2026. This court shall consider on the next date as to how the instant petition, as to why this court should entertain the present petition. Taking into account, this court shall hear on the next day as to why the petition, as to whether the instant petition is required to be entertained, taking into account that the petitioner has an alternative and efficacious remedy for the CSAT, not SESAT. More particularly when the petitioner have already availed remedies before the statutory authorities against the revisional order. And thereupon, instead of filing an appeal thereagainst before the CSAT, has directly approached this court under 226 of the Constitution. So, the learned counsel appearing on behalf of the petitioner submits that you make appropriate submissions on the next day. Interim order passed earlier shall continue till the next day.
May I correct only one thing? But the appeal was not filed by us, Lordship. The order was after the passing of the revisional order, the authority itself filed an appeal against its own order. I have not filed the appeal.
Are you sure?
Yes, Lordship. Respondent number 5 has filed the appeal.
Yes, Lordship, is my point is correct.
They have filed the appeal. I have not filed the appeal.
Page 195.
Then why you are concerned with the revisional order?
Because both the revision and the appeal was passed, orders were passed without hearing us, Lordship. Proper opportunity of hearing us. That's why we are before you, Lordship.
Which one? Then why you are concerned with the revision?
Lordship, first of all, the revision was done without hearing, affording us any opportunity. Next, the
No,
appeal.
what did they do in the revision?
So probably my landlord point is not correct. He was hard. Page 200, paragraph 11.
Appeal petition in the matter of MRS. Why did you file an appeal? This is a revision.
Revision order has not been annexed.
No, this is the order of revision.
Appeal. It's in the appeal. Not the page 200.
Appeal problem. We didn't get
What is that? Page 192?
192.
192 is the appellate order.
Appellate order. Order in appeal.
You are present in the appellate order? Yes. Page 200, paragraph 11.
But those were not considered, Lordship.
What?
Those were not considered, Lordship.
What
My
not considered?
presence was recorded, but none of my documents
So
were.
that is a case of appeal. That's not a case of the jurisdictional error.
Lordship, let it come up.
And on the next date, comma, this court shall hear. আগৰ এইখিনি লিখিব খালি সেই লাষ্টৰ এইখিনি কণ্টিনিউ এইখিনি যে মই যে লিখিছো সেইটো on the next date interim order partially shall continue on the next date the learned counsel appearing on behalf of the petitioner shall apprise as to why this court should entertain the instant with petition taking into account the petitioner has an alternative remedy available before the CSET. What is this matter?
Shifting of obstacle. The lordship judgment, lordship find at page 44, madam, covered here.
Understood, but why should I take it up? The bench 5 matter.
The other day, my lord, this matter was,
So what?
was taken up by your lordship.
I think that's problem.
We take it up on the reopening. No heavens is going to. Reopening, I'm taking a bench for.
Yes, my lord.
I'll take it then. But why did you mention this matter? You know, Mr. Saikya.
My lord, that was.
We have, when we allow certain mention, we do it on good faith.
I
Don't you
was
think
under
so?
the impression that this matter.
Hmm?
That's the point. Madam, I was under the impression that this man, she is taking up bench 4 and bench 5.
No. Then if I'm taking
That's
bench
my
4 and
mistake.
bench 5, you cannot mention the matter before me.
That was my.
You see, the thing is, Mr. Saikya, we trust the lawyers. When you asked it, I gave you the permission.
Yes,
But if you take advantage, then obviously next time will be very circumspect. But has your license, what is your state of your license? License is expired,
that's renewed, madam.
renewed. That day I passed one order. This is the order. No,
Same order lordship was passed.
no, last time I passed one
Other
order.
case number, I'll give the other case number. That day. 1884 of 2026. WBC 1884 of 2026.
Because there I've changed one thing out there because license is,
But that
now
was-
license has been extended.
Yes, madam.
We dispose it though.
So, you know, let's keep up with the.
Next time, don't do that.